Evening, friends. Connecting on a Wednesday to continue with the master series on the arbitration law, where we learned the procedural law, and today we would be discussing procedural law with more on the substantive law. Those who have been connected with us on our WhatsApp groups, we have already shared the notes, which are quite exhaustive with the judgments prepared by Justice R.D. Dhanuka, a judge of the Bombay High Court. And we are quite enamored by the fact that he has accepted our invite to disseminate knowledge on the arbitration, which we all know, especially during these lockdown times, has taken a different leap, the way it has to be done on the virtual platform, etc. And the judgments during this time have also actually given us a different flip. But what is the legal journey of the judgments and how they were instrumental in the changing of the Arbitration Act, as Justice Roshan Dalvi, who's also connected with us today on the platform, she gave us the insights as how the Act from 1940 changed to 1996, then 2016, and then 2019. Before we proceed, I will just ask Justice Roshan Dalvi, who was the connecting point with us, to say a few words, and then we will request Honorable Mr. Justice R.D. Dhanuka, a judge of the Bombay High Court, to show us the lead for all this legal journey of the judgments. Over to you, ma'am.
Good evening, friends. I can hardly speak anything in front of Justice Dhanuka. He is the authority on arbitration. But it must be only said that it is such an opportune webinar because arbitration has and must come up by leaps and bounds. It is an alternative, additional dispute resolution, and it must be done in the best possible way according to the spirit of the legislation so that we can contribute to the economy of the country as lawyers and judges. And the law which has been laid down, especially the law which relates to how you have to not delay an arbitration, how it has to be expedited and done with expediency, it all shows what the country requires. And Justice Dhanuka will be telling us about the laws that are applicable for the various sections of the Arbitration Act, because he is really the authority, I may say again. Thank you.
Thank you, ma'am. And thank you so once again. Yes, sir.
My sister judge, Justice Roshan Dalvi, Mr. Vikas. First of all, I must thank both of you to involve me also in this process of learning and sharing experience with all of you in the field of arbitration. I had benefit of listening to the lecture of my sister on YouTube delivered by her last week, and I am immensely benefited with that. I will not try to repeat what my sister has already told you on the last occasion, but if there is any repetition, please pardon me. First of all, before I go to the case laws, very briefly I will tell you the scheme of Arbitration Act, what provisions are useful and important to all the advocates practicing on arbitration side, in what sequence those provisions will be applicable, what should be considered by the lawyers or arbitrators practicing on arbitration side. So first of all, the most important section is about arbitration agreement. Because unless arbitration agreement is entered into between the two parties, dispute cannot be referred to arbitration. All of you know that arbitration agreement is defined under Section 7 of the Arbitration Act. It can be part of the main agreement. It can be part of any correspondence by exchange of letters, fax, telex, or asserted in the statement of claimant, not denied in the written statement. And the last part of it is by doctrine of incorporation. If in a signed document there is a reference to a document recording arbitration agreement, and intention of parties is that that arbitration agreement shall be part of the main agreement. Then by doctrine of incorporation, even that agreement is construed as arbitration agreement under section 7. As an advocate, when a client comes to you and he makes a suggestion that let us go to arbitration, then what is your duty? To first check there must be an arbitration agreement. If there is an arbitration agreement, then you have to see what is the procedure for appointment of arbitrator agreed upon by the parties under the arbitration agreement. You have to follow that mandatory procedure, and then only you can invoke arbitration agreement. Now, what happens if cause of action has arisen and one party who is aggrieved, he wants to refer the dispute to arbitration? Then a notice for appointment of arbitrator has to be issued to the other side in accordance with the arbitration agreement. If there is no such agreement prescribed about the procedure, then you have to follow the procedure under section 11 for appointment of arbitrator. If within 30 days of the receipt of notice for appointment of arbitrator, if other side does not appoint an arbitrator, then one party who gives notice cannot unilaterally appoint an arbitrator. In that event, application under section 11 of the Arbitration Act only can be filed by such party. But if arbitration agreement provides for appointment of 3 arbitrators, in that event, one party to the dispute can nominate his own arbitrator. The second party can nominate his own arbitrator. And if there is any difference of opinion between the 2 arbitrators nominated by the parties to appoint a presiding arbitrator, in that event, section 11 has to be filed before the court. But if there is disagreement, one party suggests few names, other side does not agree to the names, then also you have to file application under section 11(6) before the High Court. Now, what is the relevance of section 11(6) and section 11(9)? 11(6) can be approached in case of a domestic arbitrator where both parties are Indians. In case of a foreigner, a company or party residing abroad, company registered abroad, in that event, in case of such dispute, it will be an international commercial arbitration within the meaning of section 2(1)(f). And if any such dispute arises, then application for appointment of arbitrator, if arbitrator is not appointed by consensus, then has to be made before the Supreme Court of India and not in High Court. So these are the basic things about the arbitration agreement. Now, arbitration agreement can be arrived at even subsequently. It is not necessary that it should be part of the agreement at the threshold. Arbitration agreement can be recorded even in the pending proceedings before civil court or even writ court, even sometimes criminal court, if the dispute is capable of being adjudicated upon by arbitration. Suppose a suit is filed, and at some stage, even before Supreme Court, parties are able to be persuaded to refer their disputes to arbitration. Then, as you all know, under section 89 of the Civil Procedure Code, parties can record that arbitration agreement even in those proceedings. But the latest Supreme Court judgment says that oral arbitration agreement arrived at between the parties in any such proceedings cannot be permitted. Parties have to place such agreement in writing even before such proceedings, whether in High Court or Supreme Court or even before any tribunal. Unless that is done, arbitrator cannot be appointed. But if in those proceedings, if arbitrator is appointed for the first time by entering into an agreement, in that event, those proceedings are disposed of, and thereafter all the rights and remedies of the parties would be governed by the provisions of Arbitration Act. So once you are clear that arbitration agreement is there, dispute has arisen, you can refer the dispute to arbitration. the next immediate question which arises for consideration is that what can be referred to arbitration? Whether all disputes can be referred or there is bar in respect of some of the disputes which cannot be referred though arbitration agreement exists. There, the leading judgment of Supreme Court in case of Booz-Allen's, I'll just, I have given in my note, but for your benefit, I'll just read two paragraphs of the said judgment.
If you want in the notes, you can tell us which page it is because we have shared the notes also.
I'll say Supreme Court has taken a view. I'll just briefly summarize that any subject matter of dispute which is not capable of settlement by arbitration under the law for the time being in force, such award is liable to be set aside. Supreme Court has enumerated some of such non-arbitrable disputes and held that such action would be an action in rem and not in perso rem. Then it is not arbitrable. Supreme Court has categorized those disputes which are not arbitrable. Disputes relating to criminal offense, matrimonial disputes, guardianship matters, insolvency and winding up matters, testamentary matters, eviction or tenancy matters, suit for enforcement of mortgage by sale of property, intellectual property dispute, and the dispute between the trustees and the trust relating to a trust registered under the local act or Indian Trust Act. Even such disputes can't be referred to arbitration. The reason behind that is this, that only an action in personam, where the dispute is between two parties to the arbitration agreement, only can be referred to arbitration because those parties who are parties to the arbitration would be bound by the outcome of such proceedings. Whereas if the dispute is, the action is in rem, where not only the parties to the arbitration agreement would be affected, but even third parties. And those categories I have just informed you after reading from the Supreme Court judgment, that those categories of disputes will be an action in rem and matter can't be referred to arbitration, even by consent of parties. Please keep that in mind. Even though arbitration agreement exists, in case of a tenancy agreement, matter cannot be referred. In case of a criminal offense, both parties may say that all right, our XYZ is a person of reputed, a reputed person in the field or our family friend, we will go to him. He will decide what punishment should be given to the culprit. That can't be done. Another thing is that those disputes which can be decided only by a particular court having exclusive jurisdiction, only those courts will be having jurisdiction to decide those disputes and not by the arbitral tribunal. Now, what happens if a matter is referred to arbitration in spite of an action being in rem? Then, in that event, the respondent has to raise an objection under section 16 before the learned arbitrator, before filing first statement of defense, that look, this claim is not arbitrable because it is an action in rem, and arbitral tribunal has to give his ruling on that objection, whether he has jurisdiction or not. But the view taken by Supreme Court also is that if an action is an action in rem and no such objection is raised under section 16 of the Arbitration Act at the threshold before the learned arbitrator, whether that may amount to waiver or not, the answer rendered by the Supreme Court is that if an action is an action in rem and though no objection is raised, or by silence or by agreement, parties have conferred jurisdiction of the arbitral tribunal, that cannot be permitted, because if arbitral tribunal cannot decide such action in rem, then even if no objection is raised under section 16, it will be a case of inherent lack of jurisdiction. And in that event, the High Court under section 34 also can set aside an award, though an objection is raised. In my note, I have dealt with several such situations One is in case of copyrights, when no objection was raised by the respondent under section 16 before the learned arbitrator, and arbitrator decided an issue relating to copyright. An objection was raised for the first time in the petition filed under section 34. That was an action in rem. Therefore, arbitrator was not capable of adjudicating upon the action in rem. It was a clear case of inherent lack of jurisdiction. The other side raised an objection that you did not raise this objection before the arbitrator under section 16. Therefore, it will amount to a waiver under section 4. The High Court took a view that since it was a clear case of inherent lack of jurisdiction, therefore, though this objection was not raised under section 16 in the first statement of defense before the learned arbitrator, the court can set aside such award on the ground that it was incapable of being adjudicated upon by the learned arbitrator. In another case of waiver, I must, since we are on the issue of waiver, I must give you another illustration. That was a case which I had decided in Bombay High Court, where two of the family members, two sets of family members, they had some dispute regarding properties. So they appointed one lay person as an arbitrator, one of the family friend. And the arbitrator was also not familiar with the procedure. So what he was doing is that he was consulting both the parties, sometimes in presence of each other and sometimes even separately, about their respective claims and respective defense orally. And on the basis of such oral discussion with the parties, the learned arbitrator made an award. That award was challenged before Bombay High Court. The respondent in that petition raised an issue that you did not raise any issue before the learned arbitrator that there was no statement of claim filed by the claimant, and therefore it amounted to waiver. You cannot be allowed to raise that issue for the first time before the court under section 34. The Bombay High Court took a view that statement of claim is must under section 23 of the Arbitration Act, because unless statement of claim is filed, the respondent does not get an opportunity to deal with the case of the claimant. And unless he has opportunity, there is no question of the arbitrator adjudicating upon the oral discussion by treating such oral discussion as statement of claim and statement of defense. So there is no question of waiver. Now what section 4 says, if to the knowledge of parties, any part of the arbitration agreement, any procedure prescribed under the arbitration agreement, or any provision of the Arbitration Act under part 1 is derogable, and the other side does not raise an objection within the reasonable period or within the time prescribed under the Arbitration Act, in that amount it will amount to waiver. In one of the judgment, interesting judgment before Supreme Court in case of Narayan Prasad Lohia versus Nikunj Lohia, there what had happened was that two arbitrators only proceeded with the proceedings contrary to section 10, and no objection was raised. One was appointed by claimant, another was appointed by respondent. And that objection was raised by the unsuccessful party before the Supreme Court straightway for the first time, that it was contrary to section 10, because there could not be two arbitrators, either there has to be 1 or 3 or 5 odd numbers. Supreme Court took a view that this part of section 10 was a derogable provision. Therefore, since you did not raise any objection by filing your objection under section 16 at the relevant time, then this will amount to waiver. You can't take a chance after you have failed before the learned arbitrator. So these are 1 or 2 important illustrations I have given for your kind consideration. Now, what happens if a party to the arbitration agreement dies, or the party is a company, or party is an individual? Then whether arbitration agreement comes to an end or not? The answer is that arbitration agreement does not come to an end, That safeguard is provided under section 40 and 41 of the Arbitration Act. In case of an individual, his legal heirs can be impleaded as parties, or his legal heirs can pursue the arbitral proceedings if they are claimant. In case of a company being wound up, then official liquidator comes on the scene and he has to be impleaded as a party, or he can pursue the claim if the claim was filed by the company in liquidation. Similarly, in case of insolvency, official assignee has to be brought on record, or he can pursue the proceedings on behalf of insolvent. The proceedings does not come to an end. Another situation of this type I must deal at this stage is that suppose arbitrator is appointed for the first time by the parties in the other proceedings, maybe suit, maybe writ petition, maybe appeal, maybe criminal proceedings, or any proceedings even before Supreme Court. And both parties agree to appoint XYZ as a named arbitrator. In that arbitration agreement arrived at in those proceedings. Now, if that arbitrator resigns, or he does not want to proceed at all, or he dies, something happens to him. In that event, what happens? Whether arbitration agreement, which is arrived at in such proceedings under section 89 of CPC, would come to an end or not. Well, in one of the judgment, I'll give you the citation in my note. It is there. The Dheriavan's case, Supreme Court took a view that once arbitration agreement is entered into, it does not come to an end even if arbitrator dies or he doesn't want to proceed, or he has become he is not interested. Arbitration agreement will come to an end in this event only if the arbitration agreement itself provides that there would be no further arbitration if this arbitrator does not want to proceed, he resigns, or something happens to him. Unless there is a prohibition from appointing a substitute arbitrator, arbitration agreement does not come to an end, and the proceedings have to be proceeded with by appointing a substitute arbitrator under section 15 of the Arbitration and Conciliation Act. Now, arbitrator can be also appointed. There may be a different situation. That also I must tell you. Under section 8, if in spite of the arbitration agreement, if one of the parties files a suit against the other party to the arbitration agreement, then what happens? Then the defendant in that suit has to file an application under section 8 before filing his first statement of defense or merits, and raise an objection that there exists an arbitration agreement between the parties. The parties to the suit and parties to the arbitration agreement are same. The dispute which is subject matter of the suit is also covered by the arbitration agreement. In that event, the view taken by the Supreme Court consistently is that it is duty of that court to refer parties to arbitration. Of course, court has to take a prima facie view whether arbitration agreement exists or not. Court also has to see whether all the parties to arbitration agreement are parties to the suit, and vice versa. If there are, say, 6 defendants in a suit, but the arbitration agreement is only between 3 parties out of those 6, and there are some reliefs claimed outside the purview of the agreement entered into between the parties. In that event, whether dispute can be, whether parties can be referred to arbitration or not. In case of Sukanya holding, which is a leading judgment, I have given citation in my note. It is held by the Supreme Court that in that event, court has no power to split cause of action. There must be all parties to the arbitration agreement should be parties to suit. The entire cause of action in the suit should be governed by the arbitration agreement. Then only it can be referred. It can't be that for 3 defendants who are not parties to arbitration agreement, arbitration proceedings will go on, and for remaining 3 will be before the court. So there is no question of split of cause of action. Section 8, if court refuses to refer parties to arbitration on the ground that there does not exist any arbitration agreement, or there is so some parties are not parties to the suit who are parties to the arbitration agreement. That order is now made appealable by virtue of 2015 amendment by providing a remedy of appeal under section 37(1)(a), which was not there prior to 2015. Now, after section 8, the next important section is, at this juncture I must deal with, is that who can appoint an arbitrator. You must have come across large number of finance company agreements or government agreements between a contractor and government undertaking, or railways or ONGC and all that. You will find the right to appoint an arbitrator is most of the time vested in the employer, the company, exclusively. Now, that was going on. The view taken by Supreme Court was that if parties have agreed to such agreement and they have signed such agreement, then there is no question of backing out. They cannot be allowed to raise an objection subsequently that the employer has been given exclusive right to appoint arbitrator. I was not given a say to appoint arbitrator. Considering all this situation, in 2015 amendment to section 12, and by inserting schedule 5, 6 and 7, it was provided that the arbitrator should not be related to the parties or should not be interested in the subject matter of dispute referred to him in any manner whatsoever. Schedule 5 gives a big list of such persons who cannot be appointed as an arbitrator. The view taken by Supreme Court is that it provides for a guideline. But similar list is also provided in Schedule 7. And if it is found that the arbitrator proposed to be appointed or already appointed falls under Schedule 7, then he will be disqualified to act as an arbitrator. Therefore, when an arbitrator is appointed by parties without taking intervention of court, then the arbitrator has to disclose his interest by filing a statement of disclosure that he is not related to any party, he is not interested in the subject matter of the dispute, and in view of this amendment, he does not fall under any of the categories under Schedule 5 or Schedule 7. If court has to appoint an arbitrator under section 11(6), in that event, before appointing an arbitrator, court seeks such statement of disclosure from the prospective arbitrator. And once such disclosure is given by him, then such statement of disclosure is taken on record and then arbitrator is appointed. But it may be that during the course of hearing, the arbitrator may get any of such disqualification. In that event, what happens? Then under section 12, it becomes the duty of the arbitrator to disclose such interest from time to time till he makes an award. If he does not disclose for whatever reasons, or for the reason that he will have to return the brief, that is not the criteria. If it comes to the notice of the court in that event, his award will be set aside on that ground that he ought to have disclosed. In one of the matter before Bombay High Court, Justice Deshmukh, when his lordship was in our court, had taken a view that the arbitrator was appointed by one of the party in some of the proceedings in court, and he did not disclose that fact to the other side, that he was appearing as a counsel for one of the party who had appointed him. Other side was not aware, therefore he did not raise any objection. The matter came to High Court under section 34. Court took a view that the arbitrator ought to have disclosed his interest And since he was not impartial and not neutral, therefore his award has to be set aside. Now, there are some judgments taking a different view, unfortunately. One line of judgment of Supreme Court is that when 2015 amendment came with effect from 23rd October 2015, then all cases where proceedings had already commenced prior to that date, there these amendments will not apply. So if arbitrator is already appointed as named by the parties in the agreement, and only one party is allowed to appoint arbitrator, in that event, you cannot be allowed to raise an objection or not. Another set of judgments is that no, if you are disqualified because of the amendment, then even if objection is not raised, then also court can interfere with such award subsequently. And if parties agree, a fresh arbitrator can be appointed by consent. So this is about section 12(5). Another thing is that once an objection is raised about the impartiality or neutrality of the arbitrator within the time prescribed under section 12, then that objection has to be decided by the arbitrator. If he doesn't decide that objection at all, then you can challenge that along with final award under section 34. If he decides that objection and would say that I will be neutral, I will be impartial, because no arbitrator will say that I will be partial or I will not be neutral, then you cannot challenge that decision. Then and there, you have to wait till the final award is rendered by the arbitrator. And if you are aggrieved by the final award, you can challenge that decision along with final award under section 34 of the Arbitration Act. Now, which proceedings? One must know. All advocates will kindly consider this section, which is most important for all of you. That in view of section 5, which provides for a limited judicial intervention, whether you can come to court against any proceedings. Answer is no. On plain reading of section 5, it is clear that only those proceedings which are provided under the Arbitration Act, court can intervene judicially and not otherwise. Which are those proceedings? The proceedings are under section 8 for referring the parties to arbitration when the defendant applies for referring the parties to arbitration. Section 9 for interim measures. Section 11 for appointment of arbitrator. Section 14 for a declaration that the mandate is terminated. Section 15 for substitute of arbitrator. Section 27 for seeking court's assistance in recording evidence or on other issues. Section 29A for extension of time to make an award. Section 34 for impugning an arbitral award. And section 37, which provides for an appeal. Except these proceedings, court has no power to intervene. I'll give you an illustration to make the position clear. Suppose during the arbitral proceedings, arbitrator refuses to grant adjournment, or he does not frame issues as you want him to frame, or he does not allow you to cross-examine on a particular issue. He shuts your cross-examination. Whether all this, or he is demanding exorbitant fees, can you come to court at that stage? Answer is no. You will have to wait till an arbitration award is rendered, and if you are aggrieved by that. That is the scope of section 5. Therefore, please don't rush to court against every decision of the arbitrator. Please see whether it is an interim award, or it is final award, or it is one of the appealable order under section 37 of the Arbitration Act, and not otherwise. If you come to court, court will dismiss that as premature. Your client will lose his time and money, and he may he may take you to bar council. I don't know. It depends on the client to client. So be careful before choosing any proceedings. Now, about section 11, I must tell you because my sister Dalvi told me that you concentrate on section 11 more in addition to other sections. The background of section 11, I must tell you, is that prior to 2015 amendment with effect from 23rd October 2015, the provisions of section 11 was that if parties fail to appoint an arbitrator, then an application under section 11(6) in case of domestic arbitration and 11(9) in case of international commercial arbitration was required to be filed before Chief Justice of High Court or Chief Justice of India, as the case may be, and Chief Justice of High Court or his designate, any judge to whom that work was assigned by Chief Justice. And similarly, in case of 11(9), Chief Justice of India or his designate would pass an order for appointment of arbitrator. Now, the view taken by Supreme Court in 2002 in case of Konkan Railway versus Rani Construction was that since the wording of section 11 is that application has to be filed before Chief Justice and to be heard by Chief Justice or his designate, therefore those proceedings were not judicial proceedings, but any order that would be passed in such type of proceedings would be administrative proceedings, and the orders would be administrative orders. Now, consequence of that decision was very serious. I must say that. What was the consequence? That if order passed by Chief Justice or his designate is considered as an administrative order, then that order could be challenged by a writ petition in the same High Court. And two judges junior to Chief Justice could set aside the decision of Chief Justice. Similarly, in case of proceedings before Supreme Court, the decision of Chief Justice of India could be challenged by Article 32 petition, and that could be set aside by two junior judges of the Supreme Court. Another problem faced in all these proceedings was that if an order is not passed in a judicial proceedings, in that event, provisions of Limitation Act cannot be made applicable because proceedings are not before court. Provisions of Contempt of Court Act were not applicable. CPC was not applicable. As a result of that, if the order passed by Chief Justice or his designate was not followed by any of the parties, unsuccessful party, in that event, there was no remedy available to a party for enforcement of that order. Now, as a result of all this crisis all over India, in 2005, 7 judges of Supreme Court in case of SBP versus Patel Engineering Limited ultimately took a view that no, proceedings before Chief Justice or his designate in case of High Court or Chief Justice of India and his designate before Supreme Court are the judicial proceedings. They don't pass any order in administrative capacity. But the problem was not immediately solved even with that judgment. Ultimately, in the year 2015, with effect on 23rd October 2015, the word Chief Justice and Chief Justice of India in section 11 was substituted by the word court. As a result of that, all proceedings are now before court, as the case may be, domestic arbitration before High Court, international commercial arbitration before Supreme Court. Now, what is the consequence of that amendment? Consequence of that amendment is that provisions of Limitation Act is applicable. Provisions of contempt of court is applicable. Provisions of CPC is applicable. And the judgment of Supreme Court in SBP versus Patel Engineering also says that such order of court, such order of Chief Justice or his designate sorry, if it is not the proceeding, if this is not the court proceeding, then situation is different. But if it is a judicial proceeding, then all these provisions will apply. Recently, I had occasion to where under article where section 11 was filed, and the respondent raised an objection about limitation in filing that application under section 11(6). This was the application after post amendment 2015. That in view of the amendment to section 11(6) and 11(9), and the word Chief Justice is substituted by court. Now, Article 137 of Limitation Act would be applicable to the proceedings under section 11(6) and 11(9). This court also took a view that the limitation prescribed for filing an application under section 11(6) and 9 cannot be mixed up with the limitation in making a claim. These are two different aspects, two different articles apply for making a claim, as well as filing an application under section 11(6) and 11(9). So take, for example, money claim. There is a different article under the Limitation Act in case of specific performance or for possession or for a declaration. Whereas under Article 137, which is a residuary article for limitation in case of an application, limitation is of 3 years from the date when cause of action accrues. Now, at this stage, I must also tell you that as far as limitation for filing an application under section 11 is when an application, when a notice is issued by one party to another for appointment of arbitrator, and within the time prescribed, if the other party does not appoint an arbitrator, in that event, limitation to file an application under section 11(6) commences under Article 137. So take, for example, on 31st December 2012, you give a notice to the other side for appointment of arbitrator. Within 30 days, it does not appoint arbitrator. So after the expiry of that 30 days, you get 3 years limitation under Article 137 to file an application under section 11(6). But if on the date of giving that notice for appointment of arbitrator, if your claim was already time barred much prior to the date of notice, in that event, though arbitrator may be appointed under section 11(6) or 11(9) by the court, but arbitrator will have to decide whether your claims are barred by law of limitation or not by applying the applicable article of Limitation Act. These are two different situations of limitation. This should not be mixed up, should be kept in mind. Then section 14 provides for termination of mandate of the arbitrator in certain circumstances. If there is gross delay on the part of the arbitrator, or he becomes, or there are other situations arising therein, in that event, the respondent has to apply before one of the parties has to apply before the arbitrator to declare that this mandate is terminated. But if he doesn't do anything, then what happens? Then in one of the judgment in Sanghvi's case, Supreme Court has taken a view that such party can file an application under section 14 before the concerned court for a declaration that mandate is terminated. And if court is convinced that mandate is terminated, in that event, mandate will be terminated. But please keep it in mind that arbitration agreement does not come to an end even if mandate of such arbitrator is terminated. In that event, there is a vacancy. You can follow the procedure prescribed under the arbitration agreement and apply for appointment of substitute arbitrator under section 15 by making an application before the High Court or the Supreme Court as the case may be. So that is again 14 and 15 are relevant. What is section 16? Section 16 is again, as I have told you, the objection about the jurisdiction of the arbitrator has to be raised before filing statement of defense. If it is not raised, then it will amount to waiver. If it is the complete lack of jurisdiction, even if objection is not raised, it can be raised for the first time in High Court under section 34. If arbitrator decides that he has jurisdiction and the claims are arbitrable, in that event, that decision cannot be challenged till final award is rendered. And if you are aggrieved by final award, you can challenge that decision along with final award. But if arbitrator takes a view that yes, there is no jurisdiction, in that event, you can challenge that order under section 37, 1B of the Arbitration Act as one of the appealable order. Now, recently, the controversy arose at the stage of section 11, read with section 16, whether arbitrator can be appointed by the court under section 11.6 or under section 11.9 if the main agreement containing arbitration agreement is not sufficiently stamped. Then whether it is required to be first sufficiently stamped before appointment of arbitrator, whether such document is required to be impounded. Similar objection was also raised in an application under section 9, where objection was that if document is not sufficiently stamped, then how can interim relief be granted by court? Full bench of our court, Bombay High Court, took a view in that matter that no, stamping is a procedural aspect. Stamp duty will have to be paid at some stage. But merely on that ground, court cannot refuse to appoint an arbitrator. And at the same time, court cannot refuse to grant interim relief. If you ask party to pay stamp duty or apply for adjudication, and if that procedure takes 6 months or so, in the end, if during that period, if that remedy of interim relief lapses, then who will be responsible? However, in another matter, Justice Kulabawala of our High Court took a view under section 11.6a, that was an application for appointment of arbitrator. And in view of amendment to section 11.6, by inserting 11.6a, that court's power is confined to see that only arbitration agreement exists or not. He took a view that whether document is sufficiently stamped or not will have to be seen by the arbitrator. Court cannot go into that. Court has to only see whether arbitration agreement exists or not. So in case of Garware, Waldrop, the Supreme Court, while dealing with appeal against that order passed by Justice Kulabawala, took a view that no, that is not the correct view, because if agreement is not sufficiently stamped, then it is not an agreement in eyes of law. It is not admissible document. Therefore, till such document is sufficiently stamped, it is required to be impounded. It has to be sent for adjudication, and after adjudication only, stamp duty is paid, arbitrator can be appointed by the court. And while delivering that judgment, the judgment of full bench of Bombay High Court, the Supreme Court said that since this court has already taken the view that in case of insufficiency of stamp, Section 11 application cannot be entertained. Part of the judgment of full bench of Bombay High Court was overruled, though there was no appeal filed against that judgment. The situation now, what we are facing is, I must, as a student of law, I have no jurisdiction to make any comment on any judgment. But I want to bring it to your notice that because of this piecemeal setting aside the judgment of full bench of Bombay High Court, the issue whether if document is not sufficiently stamped, whether interim relief can be granted under Section 9 or not, that order of the full bench remains, and it is binding on all of us in Bombay High Court and the lower courts. But under Section 11, if document is not sufficiently stamped, arbitrator cannot be appointed. So this is very peculiar situation where interim relief can be granted without sufficiency of payment of stamp duty, and arbitrator cannot be appointed if document is not sufficiently stamped. The similar view is also taken subsequently, without of course noticing the earlier judgment in case of Garware Wardrobe by 3 judges. Be appointed if document is not sufficiently stamped. So this is another situation. Now, what is happening? The practical aspect considered by the litigants is that the view taken by Supreme Court is that if arbitration agreement is part of the main agreement which requires payment of stamp duty, and if that is not stamped, then arbitrator cannot be appointed. But there is no payment of stamp duty on the arbitration agreement executed standalone, because agreement can be by exchange of letters, any correspondence by telex, telegram, or even if it is pleaded in statement of claim and not denied in written statement. So in that type of situation, there is no question of such arbitration agreement, which are also facets of arbitration agreement under Section 7. If that is so, then you can apply for appointment of arbitrator based on such agreement recorded by telex, telegram, or by letter. So there are two situations. Parties may now, to come out of the judgment of Supreme Court, may enter into a separate agreement on in writing by exchanging letters and apply for appointment of arbitrator, so that dispute can be referred to arbitration. What happens? One of the question asked in the last session, what I have noticed is that if arbitrator is appointed or not appointed in proceedings under Section 11, then what is the remedy available of such party? The Supreme Court has made this position clear in case of SBP versus Patel Engineering by 7 judges judgment, that such order cannot be challenged by writ petition or any other proceedings other than special leave petition under Article 136 of Constitution of India. So that law is now settled down once for all. Another proceedings which you may come across or you may be tempted to file, as I told you, scope of judicial intervention under Section 5 is very limited. But if you feel aggrieved by any of the decision of the arbitrator, which is neither appealable nor is an award, you may be tempted to file a writ petition under Article 227 or 226 of Constitution of India before High Court. That issue is also decided by 7 judges judgment in case of SBP versus Patel Engineering, that writ petition is not maintainable against an arbitrator. Arbitrator is not a court, and therefore arbitrator is not amenable to a writ jurisdiction. It doesn't come under power of superintendence. Therefore, only such proceedings which are permissible under the Arbitration Act you can file, and not a writ petition. If you can't file appeal or you can't file arbitration petition for challenging an award, that cannot be circumvented by filing a writ petition. So please don't file any writ petition, otherwise that would be dismissed. You please read the judgment of 7 judges. Now, once I must also say, because the latest Supreme Court judgment on interim award is, what had happened that one of the respondents raised an issue of limitation before the arbitrator, and that issue raised by the defendant was rejected by the arbitrator. That and he held that the claims are within the period of limitation. Question arose whether that decision rejecting the plea of limitation is an order appealable under section 37 or it is an interim award. Supreme Court in one of the decision, which is part of my note, has held that no, it will be an interim award, and therefore your remedy to challenge that interim award would be to file a petition under section 34 within the time prescribed. Now, if you are not aware of that judgment and you are still proceeding on the premise that that is only one of the issue raised by a party and rejected by the arbitrator, therefore you can wait till final award is rendered and it can be challenged along with final award. And in this process, 3 months are over from the date of getting copy of such order passed by the arbitrator. Then, insofar as that decision is concerned, your remedy to challenge would be barred by law of limitation. I had occasion to decide that in one of the matter where certain issues raised by both the parties before the arbitrator were decided by consent before final adjudication, and the arbitrator gave a declaratory award, and thereafter the matter remained was only in respect of quantification. The petitioner who had lost in the final award as well as in that interim award, he challenged both the proceedings at a time within 3 months from the date of getting final award, but within 6 months from the date of getting interim award. The issue arose before the Bombay High Court was that as far as limitation in case of interim award is concerned, that has already expired. Therefore, to that extent, arbitration petition is not maintainable. Only insofar as final award is concerned, of course, that is within time, but there may be other grounds of challenge. Court has to consider that. So that judgment is ultimately upheld by division bench. Now, there are other provisions of law. My sister has already told you about assistance of court required under section 27, what order can be passed. Section 19 is again an important section where it is provided that arbitral tribunal has to decide in accordance with substantive law. In case of international commercial arbitration, in accordance with the arbitration agreement between the parties and the law applicable to them. It also says that arbitral tribunal is also bound by trade and uses and custom. If there is no procedure prescribed, then arbitral tribunal has to follow his own procedure. Now, what has happened is every matter the question arises is that whether it is a summary proceeding, arbitrator is not bound by the provisions of Evidence Act, CPC. In that event, whether disputed documents also can be considered by the arbitral tribunal or not. Bombay High Court repeatedly in number of judgments, some of them I included in my note, that wording of section 19 is that arbitral tribunal is not bound by CPC and evidence, but is bound by principles of natural justice. So principles of natural justice which are incorporated in the Evidence Act and in the CPC are to be followed by arbitrator, bound by the provisions of Arbitration Act or CPC. Therefore, inadmissible documents, if accepted by the arbitrator in evidence, then that may be a part of challenge under section 34 on the ground of patent illegality or perversity. Then section 20, there are large number of judgments on that. The dispute arises in respect of seat and venue. So parties by consent can agree to a seat arbitrator, according to convenience of both of parties, may decide various venues for convenience of both or his own convenience. Section 20 has been interpreted. What has happened is that prior to 2002, in case of Bhatia International judgment, authored by my Lord Justice Variava when his lordship was, the concept of venue or seat was considered in case of an international commercial arbitration, where the seat of arbitration was outside India. But thereafter, in recent past, the Supreme Court has consistently taken a view that seat can be only one, but venue can be different. So where the juridical seat of the arbitration is agreed by and between the parties, that court having superintendence or power of or supervisory jurisdiction over such proceedings will have jurisdiction. Now, as a result of that, what has happened is that section 21E, which defines court, where if there is no arbitration agreement where suit could have been filed based on the basis of cause of action, that court would have jurisdiction. But in view of the widened scope of jurisdiction held by Supreme Court in series of judgments, that if juridical seat is different, then even in that juridical seat, no cause of action has arisen, but still only that court will have jurisdiction to entertain the subsequent proceedings. Now, please go through those judgments. I will give you the citation at the end of this lecture. If you are still under the impression that no cause of action has arisen at Mumbai, but seat of arbitration is Chennai, then Bombay court will have jurisdiction to challenge that award. There will be derailment and your client will suffer. Therefore, you will have to reconcile all these judgments, 5 or 6 judgments. I will give the citation, where Supreme Court has interpreted whether venue can be decided by the parties, what is the difference between seat and venue, whether they can be mixed up, what is the relevance of place of arbitration. All those issues, you please go through those judgments and apply to the facts of your case independently. Section 21, I must say, is very important for this reason. That section 41, which has to be read with section 43, says that arbitral proceedings commences when a notice for appointment of arbitrator is received by other side. Now, what is the relevance of this? Please keep that in mind. Section 43 says that all proceedings of Arbitration Limitation Act applies. So, once cause of action has arisen and one party gives a notice to other party that these are my disputes, please appoint arbitrator. That party does not appoint arbitrator. But the day on which he has received our notice and the time prescribed under that notice, say 30 days, has expired, arbitral proceedings have commenced. What is the effect of that? Limitation commences, limitation stops, and you have to file proceedings within the time prescribed. But in case of a suit, limitation stops when a plaint is lodged. But in arbitration, the situation is different. It stops when the notice for appointment of arbitrator is received by the other side. Thereafter, even if arbitrator is not appointed for quite some time, or claim is not filed within 3 years, that will have no relevance on the issue of limitation. Of course, arbitral tribunal in that event, if claim is not filed within the reasonable period, in that event can terminate the proceedings under section 25, read with 32. So section 23, I must tell you what is the relevance of 23. 23, an amendment was inserted with a view to see that statement of claim is filed within 6 months. Prior to that, there was no period prescribed for filing statement of claim. As a result of that, the arbitral tribunal would take its own time to decide first meeting, to decide the date of first meeting. Claimants or his solicitors or advocates would be busy, they would not file statement of claim for 6 months. Proceedings would not start. As a result of that, the 12 months period prescribed under the provisions of section 29A for completion of proceedings from the date of commencement, from the date of arbitrator having approached in connection with his appointment would expire, and as a result of that, the mandate of the arbitral tribunal would be terminated. So 23(4) will have to be read with section 29A. 29A, as I told you, prior to 29A, which was inserted on 23rd October 2015, there was no time prescribed for making an award. But after 29A is introduced, 12 months time is prescribed from the date when the arbitrator is appointed in connection with his appointment. And if within 12 months arbitral proceedings are not decided, award is not rendered, then parties by consent of parties, arbitrator by consent of parties could give 6 months extension. And thereafter, even arbitrator had no power, nor parties had power to grant further extension. In that event, an application under section 29A(4) could be filed before the High Court or the Supreme Court, as the case may be, for grant of further extension. So court in that event would see who is responsible for delay. If it is found that parties are responsible, then court will put some terms to the parties. If arbitrator is found reasonable, then court has power to reduce the fees of the arbitrator by 5% for each month's delay. Now, as a result of this, there was a lot of hardship. So that amendment to section 23(4) was inserted. And 23(4) to be read with 29A says that arbitral tribunal has to now make an award within 12 months from the date of the parties filing proceedings, filing statement of claim. So 6 months for filing statement of claim, 12 months time given to the arbitrator to decide, 6 months extension by consent of parties, and thereafter power vested in court under section 29A(4) to grant extension. So easily you get 2 years. Now, one of the amendment which says that arbitral tribunal, fees of the arbitral tribunal can while considering an application under section 29A(4), if arbitrator is found responsible. To overcome that difficulty faced by the arbitrators, an amendment is inserted in 2019 that if court proposes to reduce the fees of the arbitrator on the ground that arbitrator is responsible for delay, then hearing will have to be rendered to such arbitrator before passing any such order of reduction of fees. That is about section 29. Section 31 is again very important. I will tell you the case laws also on that. Section 31(3) says that unless otherwise agreed, reasons have to be recorded by the arbitral tribunal. 31(5) is very important, which says that both parties have to be furnished with signed copy of the arbitral award by the arbitrator. What is the relevance of that, and what is the importance of that? Importance is this, that limitation of 3 years under section 34, 3 months under section 34(3) for filing a petition for challenging an award starts from service of signed copy of the award to the party by the arbitrator. So you may come across a situation where out of the 2 parties, only one party is served with signed copy of the award. Other party is not served, either because he has not paid the fees of the arbitrator, or he has refused to accept service of the award for whatever reasons. In that event, limitation under section 34(3) does not start. So you may come across various execution proceedings filed by a beneficiary who has succeeded in the arbitral proceedings. He files execution proceedings. And when it is served, the respondent comes out with a case that he has never been served with a copy of the award, signed copy of the award by the arbitrator. The applicant would say that I have given you copy, I had received it, so it was to your knowledge that such and such award is rendered. Why have you not challenged petition? Why you have not filed petition under section 34(3) within 3 months? The Supreme Court in case of arc builders has taken a view that no, the limitation would commence only if signed copy of the award is served upon the party by the arbitrator and not by another party. That is very important aspect as far as limitation is concerned. Then section 31(7) also provides for interest that my learned sister has already dealt with. I don't want to repeat. 33 talks about correction in the award. So that also there is a time limit prescribed of 30 days on application of parties, or the arbitrator themselves can do suo motu. If within the time prescribed, if one of the party does not apply for correction, such as arithmetical mistake or clerical mistake, or award is vague or is silent, then arbitrator has to make a supplementary award. And from the date of receipt of signed copy of such supplementary award, then limitation under section 34(3) would commence. But if it is ultimately found that such application itself was not maintainable at all, and it was mischievous, then it is matter of argument whether limitation under section 34(3) would commence from the date of the receipt of the original copy of the award, first award, or supplementary award. This is again very important aspect. Section 34. You see, 34 is most crucial section of the Arbitration Act, when an arbitration award can be challenged. Various grounds are prescribed under 34. I don't have to go into each ground. You have already read section 34, and my sister has already dealt with. The ground of patent illegality is inserted in section 34 with effect from 23rd October 2015. Supreme Court in case of ONGC versus Saw Pipes, which was one of the leading judgment, had carved out various categories in which an award could be set aside, award contrary to the terms of the contract, against various other, against contrary to section 28 and all that. Thereafter, in case of Delhi Development Authority Associate Builders case, the law was further expanded by the Supreme Court by saying that if there is any perversity in the award, then also award can be set aside. But court cannot go into the factual findings. If the award is based only on factual findings, court has no power to reappreciate the factual findings or reappreciate the evidence considered by the arbitrator. That judgment was subsequently followed in case of ONGC versus GECO Enterprise, and the another leading judgment on this issue was decided in case of Sangyong. Sangyong's case, which I would like to read 1 or 2 paragraphs on section 34. After considering the earlier judgments, including in case of associate builders, Supreme Court has held that a finding based on no evidence at all, or an award which ignores vital evidence in arriving at its decision, would be perverse and liable to be set aside on ground of patent illegality. Additionally, a finding based on documents taken behind the back of the parties by the arbitrator would also qualify as a decision based on no evidence, in as much as such decision is not based on evidence. If vital evidence in arriving at the decision is ignored, even that would amount to perversity. It is held that now, in view of the ground of patent illegality inserted by 2015, so the award which could be set aside on the ground of perversity can be now set aside on the ground of patent illegality. That judgment in case of Sangyong was subsequently followed in case of Patel Engineering Limited versus North Eastern Electric Power Corporation Limited. It is AIR 2020 Supreme Court 2488. Then the latest judgment of Supreme Court in case of Southeast Asia Marine Engineering and Construction Limited versus Oil India Limited. It is reported in 2025 Supreme Court cases 164. There again, the view taken by Supreme Court is that if the interpretation of the arbitrator is a possible interpretation, then it is within the domain of the arbitrator to interpret the terms of the contract. And if two interpretations are possible, then such possible interpretation cannot be interpreted by High Court under Section 34 by taking a different interpretation. But if that interpretation is totally perverse and impossible, in that event, powers of court to set aside such award showing perversity and patent illegality under Section 34 is not taken away. So that is one leading judgment on Section 34. Now, in one of the matter, the issue arose that suppose arbitration clause provides that certain decision, you will come across such clause in case of mostly engineering contracts, where certain decisions, say take for example, in case of drawings, designs, extension of time and all that, the decision of engineer or architect or project engineer, project manager is held final in the contract. And if such decision is once given by such party, such person, such designated person, then though there is an arbitration agreement, to the extent such decision which have become final, such decisions are called decisions on accepted categories of claim. Those decisions can't be referred to arbitration. So this is the view taken by Supreme Court in case of Mitra Guha Builders India Company versus Oil and Natural Gas Corporation Limited. Para 18 of that judgment is very crucial. Then in one matter, I had occasion to decide in Bombay High Court. I'll give the citation: Bombay Slum Redevelopment Corporation Limited versus Samir Narayan Bhojwani, 2019 SCC Online Bombay 1853. There what had happened was the learned arbitrator in the final award gave various directions to third parties who are not parties to the arbitration agreement to do XYZ on their part, to pass certain orders, to sanction plan, to give this permission, that permission. And in addition to that, the arbitral tribunal also declared some of the financial transactions between the petitioner and third parties as nullity. So the view taken by Bombay High Court is that the third party was not a party to arbitration agreement, and he was not even party to arbitration proceedings. How can you give such a declaration against a third party? Because he is not bound by your third party. Therefore, the arbitral award was set aside on the ground of perversity and patent illegality. Then, under Section 34, I must tell you something interesting, including one of the lacuna which I always address in all the webinars. One is that if your claim is rejected by the arbitral tribunal, and you suppose you apply for specific performance, that is rejected, you file a petition under Section 34, or you challenge some termination of your contract. Whether court under Section 34, even if is satisfied that contract is wrongfully terminated, can grant that relief and make an award and says that contract is in existence, it is wrongly terminated. Where Supreme Court in case of McDormand versus Bernstein, 2006 judgment, I have given the citation, has taken a view that court cannot correct and court cannot make an award. Court can either set aside the award or upheld the award or partly set aside the award and leave the parties to the remedies available in law. Now, as a result of that, even if court is satisfied that contract is wrongly terminated, court can only set aside the award. the practical difficulty faced by the litigant in such type of situation is that whether arbitration agreement is exhausted after such order is passed by the High Court or Supreme Court, or you are required to file a civil suit for specific performance or for a declaration or for other reliefs. That is again a matter of debate. So this is one lacuna in Arbitration Act, according to me, that if an appellate court, whether it is district court or high court or even Supreme Court, can set aside a decree of dismissal of a claim and pass a decree, then arbitral tribunal, who is in substitution of a court, why his decree of dismissal cannot be set aside and a fresh decree be passed by the High Court. This is one lacuna which I request all of you to have a debate on this, and some amendment can be suggested to the Law Commission. Now, what happens is that another situation faced is that suppose there was an interim relief in your favor, which was in force in such type of situation when you apply for a specific performance, and ultimately your claim is rejected by the tribunal. You file section 34 petition. You want continuation of that interim relief which was in your favor, which was in force till the award is rendered, by making an application under section 9 before the court. The Bombay High Court has taken a view, Division Bench of our court in case of Dirk India, that court cannot grant any such interim relief if your claim is already rejected by the arbitrator. The logic behind that, what I understood is that if court cannot grant you final relief if your claim is rejected by the arbitrator, then there is no question of granting any interim relief. This also, in my view, is a serious lacuna under section 9. And because of the judgment delivered by our court, we face this situation that we are unable to grant interim relief, though we are of the view that claim for specific performance is wrongly rejected by the arbitrator. So there must be some amendment to this effect also. Now, section 34, there is another checkered of history which I must tell you. You see, in 2004, there was a judgment of Supreme Court in case of National Aluminium, where the view taken was that once application under section 34 is filed within the time prescribed, in that event, there is automatic stay till that application was disposed of. Now, as a result of that judgment, what was happening is that any party who has suffered from such award, he would file section 34 application within three months from the date of getting certified, getting a signed copy of the award. And he would not remove office objection. He would not even apply for early hearing of that petition. So in view of that judgment, if petition remains pending for 6 months or 1 year or 5 years, even for admission, that award was not enforceable. Now, facing this difficulty, in section 36, an amendment was introduced in 2015, by virtue of which it was made clear that there is no question of automatic stay. Any party who wants to apply for stay has to file an application in the section 34 petition. It is the power of the High Court, discretionary power, to grant stay or not to grant stay, if to grant stay on conditions or unconditionally. And what happened was that in one of the matter before Bombay High Court, the issue arose that whether this amendment with effect from 23rd October 2015 was applicable to the proceedings already commenced prior to that amendment, and even in pending matters, those parties who have got unconditional stay, automatic stay, would be required to file fresh application for seeking stay, or that provision would be applicable only to the proceedings which have commenced after 23rd October 2015. So Bombay High Court took a view that no, even in pending proceedings, you will have to apply for stay. In case of BCCI versus Kochi Cricket, and that judgment was ultimately upheld by Supreme Court. Now, 15, 2019, there was an amendment. Section 87 was introduced, by which it was provided that all 2015 amendments will apply only to the proceedings which have commenced after 23rd October 2015 and not prior thereto. And section 26 was also inserted. Now, as a result of that, position of law was clear according to the litigants and the practicing lawyers. But that amendment again created some problem for the litigants who had succeeded before the arbitral tribunal, and the old regime was restored because of that amendment, and there was automatic stay. So in one of the matter before Supreme Court in case of Hindustan Construction Limited versus Union of India, constitutional validity of section 87 was challenged. And there the Supreme Court took a view that section 87 is in violation of Article 14 of Constitution of India and is arbitrary, and therefore validity of section 87 was struck down by Supreme Court. In case of the stay required to be obtained under section 36, and as a result of that, the provisions of principles of law laid down in case of BCCI versus Kochi Cricket was restored back to original situation. As a result of that, now even in old proceedings, you have to apply for stay, and it depends on the court. Court may put you on terms to deposit the entire amount of 50% or to secure the claim by furnishing bank guarantee or some such undertaking. In 2020, they again facing the problem by litigants because of this situation, an amendment, an ordinance is issued very recently in 2020, by which section 36 is again amended, and now it is provided that court will grant unconditional stay if court is prima facie satisfied under section 34 that award is procured by giving bribe or corruption or fraud, or if the arbitration agreement is also executed by committing fraud or because of bribe and corruption. This amendment, in my personal view as a student of law, I am sharing with you, that does not solve the problem completely. First of all, at the section 34 stage, when the petition is at the admission stage, if you ask court to take a prima facie view that award is obtained by fraud or coercion or corruption, or agreement was also executed in similar fashion, then you are bound to grant unconditional stay. But how do you take such view at the admission stage, and that also prima facie stage, which finding may ultimately come in the way of the beneficiary of the award at the stage of final hearing. So if amendment could have been one way or the other, whether position could have been made clear whether all amendments of 2015 were applicable to the earlier proceedings or proceedings initiated after 23rd October 2015 or not. But this amendment does not serve any purpose completely, according to me. On the issue of limitation, that ordinance, if you want to know the date, it is dated 4th November 2020, inserted by Ordinance 2020, the Arbitration and Conciliation Amendment Ordinance 2020. Now, during the pandemic period, one of the issue arose before the Supreme Court and High Court that parties are unable to file proceedings under the Arbitration Act, either for appointment of arbitrator or section 34 or under section 27 or appeal under section 37 or section 14 for termination of mandate or 15 for substitute arbitrator. Supreme Court has taken care of that by passing an order on 6th May 2020, in suo motu writ civil number 3 of 2020, and it is ordered that all periods of limitation prescribed under the Arbitration and Conciliation Act 1996 and under section 138 of Negotiable Instrument Act shall be extended with effect from 15 March 2020 till further orders to be passed in that proceedings. In case the limitation has expired after 15 March 2020, then the period from 15 March 2020 till the date on which the lockdown is lifted in the jurisdictional area where the dispute lies or where the cause of action arises shall be extended for a period of 15 days after the lifting of lockdown. Now, as a result of this order passed by the Supreme Court, if during the lockdown you are unable to file proceedings under section 11 or under section 29A 4 for extension of time to make an award, or under any other proceedings, as I have told you, under 29A or 27 or 37 or 34, in that event that is automatically extended by virtue of this order. So you need not worry that proceedings could not be filed and it would be considered as time barred. No, you are protected by this common order. Even Bombay High Court and various other high courts have also passed orders granting stay or continuation of stay or not to demolish or evict anybody during the this pandemic situation. In two of the matters under section 34, an issue arose. Who can file section 34 petition? What had happened was that there was a development agreement between the society and the developer. And one of the member of the society carried that impression that there is collusion between developer and the society management committee. So award was decided against the society. Society was not willing to challenge that award. So one of the member challenged that award under section 34. Bombay High Court, in case of Gera, in one of the matter, I will give citation, took a view that since he was not a party to arbitration agreement, he could not have challenged that award under section 34 of the Arbitration Act. But in another matter, there what had happened, that citation I will give just now, is in case of Srimati Prema Amarlal Gera versus Mehman Cooperative Bank Limited. There, one of the third party who claimed some rights in the property which was subject matter of arbitration. He applied for intervention before the arbitrator. Arbitrator allowed him to intervene. He allowed him to cross-examine the parties to the litigation, and thereafter made an award and passed certain order of status quo against the third party to arbitration. So he filed a petition under section 34. I had occasion to decide that matter. The High Court took a view that such party, though was not a party to arbitration agreement, but he rightly or wrongly applied for intervention. Arbitral Tribunal has allowed such intervention, and once he is aggrieved by that award, because he was party to the arbitral proceedings, not to the agreement, then his remedy would be to challenge that award under section 34 of the Arbitration Act. But in another matter, where Arbitral Tribunal passed some interim orders under section 17 against a third party, then the third party filed an appeal under section 37. The question again arose that he was not party to arbitration agreement, he was not party to arbitral proceedings, whether appeal could be filed under section 37. The view taken by Bombay High Court is that yes, he was the party aggrieved. First of all, no such order against a third party could be passed by the Arbitral Tribunal under section 17. But if he is a party aggrieved, he cannot challenge that order by filing a civil suit his remedy would be only to challenge that order by filing an appeal after obtaining leave of the court. What is done in case of a civil proceedings under CPC. So that was the view taken. The last situation I must tell you is that now for execution, the view taken by Supreme Court is that you are not required to apply for transfer of decree, which in the court which could have passed a decree on the basis of jurisdiction. But you can straight away file an application for execution in the court where the principal debtor resides or his assets are situated. That is one tedious procedure given a go by virtue of the judgment of Supreme Court. Now, very quickly, some of the citation I already given you. My request to you would be to go through my note, because most of the important judgments I have already dealt with in that note, and the additional citation, because of short of time, some I have dealt with. What I will do is I will prepare one additional note and circulate to you within 1 week.
Yes, we will share that.
Which judgments I have told you during my speech, but not part of that note, because that note was prepared in the month of February 2020. So subsequent judgments, but they are very important, I have dealt with. But for as far as citation is concerned, I can give you now also, but it will take another 15-20 minutes. You tell me, Mr. Vikas, you want me to?
I'm fine in both ways, because since we will be uploading on the YouTube, we will also share it on the WhatsApp.
Yes, I'll do that. So thank you very much. If there are any questions, I'll try my best to reply.
Yes, sir. We will also unmute Justice Roshan Dalvi. And as Justice Roshan Dalvi had said, and we had read your judgments, reading the judgments and hearing, both have always been a pleasure. This is in a registered development agreement between society and a developer. There is an arbitration clause. Society intends to terminate the development agreement as there is a zero progress. Question 1. Whether society can appoint an arbitrator of its choice without permission of the court. Question 2. Whether arbitrator in above case can pass any ex parte order of cancellation of the registered payment. And Justice Roshan Dalvi, could you also get yourself unmuted so that you can also share your knowledge?
You see, your first question, whether one of the party to arbitration agreement can appoint an arbitrator or not, that party autonomy is now taken away by virtue of section 12. I read with schedule 5 and 7, that in case of Perkins, which is mentioned in my note, Supreme Court has taken a view that if only one party is given a right to appoint an arbitrator who may be beneficiary of the outcome of that award, then that party exclusively cannot appoint an arbitrator. Arbitrator has to be appointed by both parties. That party has to give notice to the other side for appointment of arbitrator. He can suggest some names. And if there is no agreement, no consensus on the names, then his remedy would be only to file an application under section 11.6 or 11.9 as the case may be. He cannot appoint any arbitrator unilaterally. He can appoint arbitrator only if agreement provides for 3 arbitrators. Then of course he can nominate his own arbitrator. The respondent will nominate his arbitrator. For that, consent of each other is not required. And those 2 arbitrators can appoint a presiding arbitrator under section 11. Otherwise, if one arbitrator proceeds on the basis of unilateral appointment, that award will be nullity and it will be set aside. I already decided in Bombay High Court that.
Yes. If the arbitrator is appointed not as per the procedure provided in the contract, the respondent took the same as a ground in statement of defense. Whether it is sufficient or the objection sought to be taken under section 16 of the Act, despite there being an objection in the statement of defense, whether this would amount to a waiver under section 4 of the Act.
You see, procedure prescribed under the arbitration agreement is part of the arbitration agreement. So if that procedure cannot be derogated, then it is mandatory and you have rightly raised that objection under section 16, because that will have bearing on the appointment of arbitrator. If suppose that stage has not come at all, procedure says that suppose certain claims have to be referred to project manager before invocation of arbitration agreement. You have not followed that procedure. You have straight away invoked arbitration agreement. In that event, your application may be premature. In that event, the appointment of arbitrator is illegal. And your objection under section 16 will have to be decided by the arbitrator, because he would not have jurisdiction. His appointment itself is illegal.
So this is by Prab Sin Mahita, that is on the Facebook. Limitation of time to appeal against an award of arbitrator tribunal in a concerned district court. What would be the limitation?
Limitation, whether it is district court or it is high court, is same. 3 months under section 34(3) of the Arbitration Act with 30 days grace. Supreme Court in case of Union of India versus Popular Construction, followed by several other judgments, has taken a view that section 5 of Limitation Act is not applicable to section 34(3), because Arbitration Act is a self-contained code. So if you file beyond 30 days, 3 months plus 30 days, then court has no power to condone delay. I must tell you one interesting judgment of Supreme Court on this. This is one of the questions. In one of the matter, the question arose before the Supreme Court that petition is filed not within 3 months, but also not within 30 days, but it is filed one day thereafter, because the 30th day would fall on Sunday or on some public holiday. The question of limitation arose. Supreme Court took a view in that matter, that judgment authored by my Lord Justice Loda, as his Lordship then was, that this 30 days period described in section 34(3) is a grace period. It is not part of limitation. That is a grace period. Limitation is only 3 months from the date of service of signed copy of the award. Therefore, if 30th day falls on public holiday or Sunday, then you don't get benefit of section 4 of Limitation Act. And in that event, the next working day would not be a period of, not be the day on which you could file petition. So that also one must keep it in mind. But recently, I must tell you, in the latest judgment of judgment delivered by the Honorable Justice Nariman, authored by my Lord Justice Nariman, the issue arose in case of limitation under section 37. The view taken by Supreme Court in that judgment is that the limitation for filing an appeal under section 37 also would be 90 days plus 30 days. Though there is no specific period of limitation prescribed under section 37 as is prescribed under section 34(3). But by applying that analogy, the view taken by Supreme Court is that 3 months, 90 days plus 30 days, you can file. Beyond 30 days, section 5 of Limitation Act does not apply, and court has no power to condone delay. This is another important judgment which one must know. The question asked to me in one of the seminar was that judgment in case of limitation under section 37 was dealing with section 34, because that limitation under 34 was for filing a petition for challenging an award. Whether this period prescribed by Supreme Court in that judgment in the appeal arising out of section 34 petition under section 37, the same limitation would apply to other appeals arising out of section 17 or section 9 or other provisions where under section 8 where appeal is also maintainable. So as a student of law, I have no answer to that, but I could only say that on my plain reading, the Supreme Court has decided the issue of limitation only in the appeal arising out of section 34 proceedings. Therefore, I don't know whether other proceedings same period will apply or there some other limitation will apply, because Bombay High Court had taken a view differently before this judgment that appeals will have to be filed within a reasonable period, because there is no limitation prescribed. And if it is not filed within a reasonable period, then court has power to dismiss that appeal under section 37. Yes.
Yes, sir. This is in an MA before the principal judge by the judgment debtor, an interim order is passed against an ex parte award by an arbitrator. An argument for making the said interim as perpetual is pending as uncontested. Can the executing court dismiss the execution in view of being not contested?
No, executing court, you cannot invoke. Because section 9 says that it can be invoked till award is executed. But your remedy is available under CPC before the execution court. And that execution court will decide what relief should be granted so as to protect the properties which were subject matter of the decree and now pending before the executing court.
This is Honorable Sir, claims of the claimants were allowed in the full by the tribunal on merits, but the pre-arbitration pendulite interest and cost of arbitration was specifically disallowed in the arbitral award by way of totally baseless observations. Can non-grant of interest and cost of arbitration is challengeable under section 34?
Yes, you are aggrieved by part of the award. You are entitled to challenge that under section 34. Because interest, of course, arbitral tribunal has discretionary power under section 31(7), unless otherwise agreed by the parties. If agreement provides that interest is not liable to be paid, then even arbitrator cannot grant. So in that event, court will decide whether it is the claim is contrary to the terms of the contract. Similarly, cost of award also, that is part of the claim. It is rejected. You are aggrieved by that. You can file a petition under section 34.
This is society and developer have a development agreement bearing an arbitral clause. Dispute arose. Developer 1 assigns the DA to a developer 2, with the society as an affirming party, a confirming party, stating that the terms of the DA are to be read as a deed of assignment. The deed of assignment has no explicit arbitral clause. Will the arbitration clause from the DA be read into the deed of assignment with developer 2 in view of the assignment of the development rights by developer 1 to developer 2?
This is a matter of interpretation. If all the provisions of the main agreement are to be read with the subsequent agreement, including arbitration agreement, in that event, arbitration agreement, in case of a dispute between those parties, assignees and the main party, can be referred to arbitration. If intention was not there to incorporate arbitration agreement under section 7(5), then that party cannot say that merely because that reference was made, parties are bound by arbitration clause in the main agreement.
This is the last question we are taking. Which is the principal court of the original jurisdiction before whom an application for interim relief is to be filed before an arbitrator is appointed? Principal court of original jurisdiction is district and sessions judge.
The principal court of, in case of a district, principal court of original jurisdiction, in case of original jurisdiction, in case of before the high court, will have to file interim application under section 9.
No, he says principal district judge or ADJ.
So there, see, in Maharashtra, I must tell you the problem. One of the view taken by our Aurangabad bench was that only principal district judge could entertain arbitration proceedings under section 9 or under section 34. So view arose whether principal district judge is the district court or not. Because of this, and another view inconsistent to that was taken by my lady Mrs. Justice Bhatkar when her lady was in our court. But because of this inconsistency, ultimately we have carried out amendment to the Maharashtra Civil Court, and we have made it clear that all judges of district court would be allowed to hear arbitration proceedings, provided that assignment is given by the principal district judge. Of course, subject to now provisions of the Commercial Court Act, that is intervened in the meanwhile. So all commercial courts defined under the provisions of Commercial Court Act also will have power to decide arbitration matters. So that problem is now is sorted out by virtue of this.
So the last question that has arisen is, in a lot of cases, the party says, I don't want to get myself cross-examined, or the parties does not cross-examine because they feel that it's a summary proceedings. What is the effect of thereof? Because both the parties have filed their affidavit and both have filed the examination chief the application. They have submitted their evidence in their part, but they have not. Both the parties have not entered into cross-examination. There's no cross-examination there.
You see, if both parties will never agree that what is stated in individual's agreement is affidavit is true and correct. So if it is disputed by other party, then what is stated in affidavit of evidence is of no relevance, because that is not a proved fact. All disputed facts and all disputed documents have to be proved by leading evidence. So that agreement, that affidavit, without being an opportunity of cross-examination, would be of no relevance. Arbitrator cannot consider that as authentic or proved averments or deposition in the affidavit of evidence.
Because both the parties have tendered their affidavits to the effect that this is my evidence.
No, but see, I'll give one illustration. The claimant has filed an affidavit asserting his case.
Yes.
Respondent has filed his case, his affidavit asserting his case and denying the case of the claimant. In that event, unless both these disputed facts are proved by leading evidence, which can be only proved if opportunity to cross-examine is given to either party. If not, then it is for the arbitrator. But in one of the judgment, I must tell you recently what has happened. Supreme Court, in case of MK, that is part of my note, had taken a view that if even at section 34 stage, if one of the party comes out with a case that certain important facts which were not to the notice of one of the party who had lost before the arbitrator ought to have been brought on record. Supreme Court has taken a view that if that is the case, then even section 34 court can allow parties to file such affidavits even at that stage. But as far as possible, no opportunity of cross-examination should be granted to the other side. Anyway, this is the view of the Supreme Court. I don't have to say anything more than this. So my personal opinion is that once opportunity of cross-examination is not given, then there is no question of relying that as proved fact.
Okay. So thank you, sir. And we'll ask Justice Roshan Dalvi to unmute herself. It was actually a pleasure hearing you and taking us to the entire act with the case law, and that too within a short span of 2 hours. It's a Herculean task, but only that person can do it who has the immense knowledge, and actually they can actually funnel out the entire law also. Otherwise, even a book, if you start reading a book on a particular act, you can't do that within 2 hours. So I would say that it was one of the best sessions where we could get the accumulated knowledge of the procedural law coupled with the law. And tomorrow, before we part for the day, tomorrow we would be having a session by Ishwar S. Anthin, a former district and session judge from Bangalore. And he would be speaking on Special Marriage Act with comparative study of Hindu Marriage Act. So do stay connected with us at 5 p.m. And before we part for the day, I will just ask Justice Roshan Dalvi, who has been helping us to connect the dots to make it line in the right perspective of this entire webinar series. We'll ask Justice Roshan Dalvi to give her insights on this session.
Vikas, I will not give any further insights because every single thing is covered. I'm only happy that you are happy with my choice.
That has always been good. That has always been good.
You say that I made a good choice. And thank you, Justice Dhanuka. It was very exhaustive. I'm speechless.
No, I must be thankful to both of you for giving this opportunity to share my experience. Thanks a lot.
In fact, the way people have logged in on the Facebook, it shows that people are actually, a lot of people have just logged. I'm seeing that a lot of people have logged in on the Facebook also.
Thank you.
And thank you, sir. And so, friends, being a Saturday, after having a good knowledgeful session, we can all relax and enjoy for the day, and we had good knowledge which can be disseminated amongst other people also. Thank you everyone, those who have been connected with us on the Facebook and this platform. And we would also share this video on the YouTube, most probably by late evening. Everyone stay blessed, stay safe. Namaskar and Jai Hind. So thank you.
Thank you.
And thank you, ma'am, once again.
Thank you.